back here with you in the WFLA Now Stream Center. JB here with you, folks. And we've lost our signal, and I believe it is because it might be battery related. The hearings have gone on much longer than anticipated, but the big breaking news that just got decided in Sarasota County Circuit Court, Judge Danielle Brewer ruling against the motion of protection for Roberta Laundrie's burn after reading letter. You heard the arguments for the motion, against the motion. You also heard conversation regarding a confidentiality agreement. Matthew Luca in a bit of comedy there, saying that the confidentiality agreement doesn't really mean much after Pat Riley mentioned some of the things that are in this letter, allegedly in court on record. So the Petito and Schmidt family, they could be granted the letter as early as tonight. And so exactly how this now takes shape and whether or not it will be up to Pat Riley, Nicole Schmidt, and Joe Petito as to whether or not they want the world to see it or whether or not they want to save it for trial. If it, of course, is admissible as evidence at trial. So that's where we currently stand. And you heard Riley there. I want to go over my notes because the notes, I was writing down quite a bit during both arguments. But Riley called Roberta's letter a critical piece of evidence. Matthew Luca, everyone agrees the letter was not dated. Judge Brewer has it in court. It does not mention Gabby Petito by name, but it does allegedly contain some disturbing references. You saw Pat Riley reference some of the books, children's books that are referenced in this letter. Brewer saying that the judge in this case saying that due process would allow Riley to argue, in essence, its relevance in this trial. Luca are counter-arguing that the letter itself hasn't caused emotional distress, which is, of course, the reason why we are here to begin with, the grounds for the lawsuit. And then Brewer also saying that Roberta Laundrie, her affidavit isn't particularly relevant because of credibility issues. So the argument should be made at trial, according to Brewer, as far as the relevance. And so really, in essence, Pat Riley's argument that a jury should determine the letter's relevance is really what won out here. And Matthew Luca, his argument that it doesn't mention Gabby Petito by name and it doesn't have a date, that those arguments weren't enough to preclude this from getting to Gabby Petito's family. So this is without question. I don't need a legal analyst here on stream to tell you this. I can assure you that legal analysts are going to say this is an enormous win for Pat Riley, Joe Petito, and Nicole Schmidt there on your screen. And also, but it also sets the stage for whether or not this letter will be released to the public. The confidentiality agreement was pretty much, that pretty much fizzled out in court. I do not see the feed coming back, which means we might be ending out our live stream sooner rather than later. But as I promised, I will be answering as many questions as possible. We did run a YouTube Live unscientific social media poll here on WFLA Now. We asked you, do you think the plaintiffs should be granted Roberta's burn after reading letter? And 93% said yes, 7% said no. Those are not surprising poll results. People want the truth. People want to know what is in this letter. Here's what I find to be particularly interesting. And it's semantics. It's semantics.
Check. Waiting on the family. Come out.
Oh, look at this.
Avis, do you want me to?
They're getting ready for a press conference. So we're now going to hear from both sides outside the courtroom, which is great to get some reaction. But back to my point, I'd like to bring this up, if I may. Perhaps one of the most interesting parts of this letter isn't in the letter. Because it's supposedly on the envelope. The words burn after reading are supposedly on the envelope. So everyone keeps talking about the letter. I know this is semantics, but is the letter going to be granted and the envelope, or the letter and the envelope? It's a small, but also not that small detail regarding how this is now going to get turned over. The letter itself will not be turned over. Quite clearly, a digital copy of it is going to be turned over. And exactly what that looks like We know some of the allegations as to what's referenced in this letter. However, the exact words from Roberta and people determining for themselves whether or not they believe it was written before or after Gabby's death. I mean, that we're going to look. It depends on if the letter is released to the public. That now is really going to be a call for the Petito family, the Schmidt family, and of course Pat Riley. And there will be a legal guidance there undoubtedly as to whether or not it's, look, if you're Nicole Schmidt and you're Joe Petito, I'm sure that there is going to be a conversation about what is best for what is the best chance for them to win at trial. This is all about, of course, you file a lawsuit to win the lawsuit, and would releasing it to the public at this stage compromise any part of their civil process as far as filing this lawsuit? And that will be up to that side of the equation to determine if they want to release it, whether it's now, later, or if it will come out at trial eventually down the road. So yeah, people talking, about the envelope. The envelope's a really important part. Will a jury see the words burn after reading, if that's exactly how it's stylized? Will they be able to see it for themselves? That's a really important point. Unless the letter was folded in half and then it was written on the back, if you know what I mean. You're following along there with my thinking. I know that we're really getting into the weeds here on a couple of pieces of paper, but those pieces of paper could be a massive difference maker as far as this lawsuit when the trial actually occurs in May of 2024. We're looking here live at the podium that has been set up outside of the courthouse there in Sarasota. As a reminder, I want to show you, this was the scene last night. This coming from Nerdy Addict on Twitter. There was a projector image put up, and you'll see exactly what it said. Justice for the Petito and Schmidt families. This was on the courthouse that we just currently were watching the feed come out of. There you can see, don't ignore the signs like the Laundries ignored the phone calls. So that was quite literally plastered or projected, I should say, rather, onto the courthouse where this hearing just concluded. Let me also make one more extremely important point, and really remember this, folks. Judge Brewer reserved her ruling on the motions to dismiss. There is always the chance, while legal analysts have said that it is a long shot, there is always the chance that she rules to dismiss and this all becomes, in essence, a moot point. The likelihood of that happening, according to legal analysts, is very slim, but Judge Brewer did make the decision to reserve her ruling on the motions to dismiss, and without reading too much into it, one of the reasons why she might have reserved ruling is because there was a much longer than anticipated set of arguments put forth on both sides as to whether or not the lawsuit should go forward. And as a reminder, the reason that we're now in this second round of potential dismissals is because this now comes with the addition of Bertolino as a co-defendant. That set the stage for another dismissal attempt by the defendants in this case. So we'll be listening in here live from outside the Sarasota County Courthouse in Venice, Florida. You can see the microphones that have been set up here. And here is Matthew Luca. We're listening in here live on WFLA now.
You guys ready? Yeah. Could you just say your name and spell it so we get it correct?
Matt Luca, Luka.
I guess, how are you feeling after all the motions? We know that the judge is going to rule on 2 other motions as well. Just how do you feel moving forward right now?
Well, it was obviously a long day, and we appreciate Judge Brewer giving us as much time as we needed to take. She was very accommodating in that regard. I feel pretty good. Feel about as good as I did walking in. We were able to make all of our arguments, and hopefully they'll be persuasive.
Yeah, with letting them use the letter as well, we know that the letter has now been handed over to Mr. Riley. What are your concerns in that aspect?
Well, obviously we were concerned about how the letter might be used, that it could be embarrassing and whatnot. But it's part of the case now. It's part of discovery. And so I'm sure it's something that we will address again as the case progresses.
Is there anything else you'd like to say about that letter? We know that we were told that there was references to children's books, but just hearing Mr. Riley, it didn't sound like that.
Yeah, we disagree with Mr. Riley's characterization. So within the letter, you'll see that there are references. I know Mr. Riley referenced two things in the letter that, taken out of context could be inflammatory, but they appear in a series of sort of fanciful descriptions of how much somebody would love somebody else. So, for example, there's a reference in there about if Brian went to the moon, his mother would be waiting for him to come back. If Brian hated his mother's guts, that she would get new guts. Things that are obviously not real. They're just fanciful descriptions, again, of how somebody would love somebody no matter what. And so in that context, we believe that the letter, as Mrs. Laundrie said, was written prior to Brian and Gabby's trip. The letter doesn't reference Gabby in any way, which would be unlikely if it was written after what happened between Gabby and Brian. So that's our position, and we believe the facts will eventually bear that out.
Can you prove that the letter wasn't given to Brian on his flight back to Moab?
Again, other than what Mrs. Laundrie has stated in her affidavit, that's our proof. There's certainly no proof that she gave it to him at that time that you described.
I just don't think that they would put burn after reading if it was just a letter to your son.
Well, so if you look at Mrs. Laundrie's affidavit, she states in there that that's a reference to a book that Gabby had given Brian that was called Burn After Writing. And basically the premise of that book is you can write your personal thoughts down and have that outlet, but then you burn it after writing it so that it gives you some closure to whatever it is that you were describing without other people knowing your personal thoughts.
Thank you.
Thank you.
Matthew Luca speaking here outside the courthouse in the aftermath of a lengthy set of hearings this afternoon. He, of course, referencing there at the beginning the motions to dismiss. Here is Pat Riley.
Mr. Riley, how do you feel? We know that the judge has two more motions to make a ruling on, but as you said, that Judge Carroll had really already made these rulings, and it's almost a disgrace to his credit as a judge to go back to these.
I would agree. I think the arguments that were made, if I were Judge Carroll, would be insulting to me because they argued that he didn't give a thorough consideration to all of the elements of the cause of action, which is clearly not true. His decision was very well written, very reasoned, and he took his time putting it together. So I think they're just seeking another opportunity to raise the same arguments, and they should fall.
Are you concerned that, I don't want to call it a waste of time, but that they'll continue to drag things out with motions like this?
Well, if the court denies their motions, then there's nothing more they can do to stop it from moving forward. We'll begin or continue with the discovery phase and then ultimately move towards trial.
How do you feel getting that letter in your hands today?
It's a victory. We're happy to have it. We fought hard to get it. We've been fighting for over a year to get that letter.
And once you have that letter, we've heard some of the phrases, some of the wordings that were written in that letter. How do you think that will help the case moving forward?
Well, the letter suggests that Roberta Laundrie would, if she needed to bury a body, she'd bring up a shovel and garbage bags. It said that if she went to jail, she'd bake a cake with a file in it. I know in court I said shiv, but that was my recollection from a year ago. It does say file. So in my mind, that clearly shows that she knew that Gabby Petito was deceased, and it's up to the jury to decide when that letter was written. Just because Mrs. Laundrie says it was written before the trip doesn't mean it was written before the trip.
I guess for the family too, not having Brian alive to go to trial, how will this continue to help with some, not closure completely, but just closing out
Well, the whole intent of this is to get answers. There are still many questions that the Petito family has about what the Laundrie family knew, what they did with the knowledge that they knew, and really why they didn't come forward and say anything. I don't know that that question will ever get answered because they, as the court has found, had the right not to say anything. But there's a lot of questions that the family would like to have answered before they can get, if you can get closure at all in a situation like this, but at least get some closure. All right, thank you. All right, guys.
Pat Riley hugging Tara Petito, shaking the hand of Joe Petito, giving a hug to Nicole Schmidt, and of course shaking the hand and embracing Jim Schmidt outside of the Sarasota County Courthouse today. They do have the letter in hand. Exactly now how they choose to proceed is completely and totally up to them as far as the evidence and the discovery process in this trial. As we see the family walk away here together. JB here with you live, folks, on WFLA now. Good evening to you. I will stay here with the live shot while we have it. And when the shot, you can see a bit of a victory moment there. That is TJ, Gabby Petito's brother, who just raised his arms triumphantly. And so it does not. There was no mention from Pat Riley about the reserved ruling as far as the motion to dismiss. It seems as if Pat Riley is quite confident that Judge Brewer will allow the lawsuit to proceed. However, she did reserve ruling, and it has to be stated for the record that there is still a chance that the lawsuit in and of itself is dismissed based on the arguments made by Matthew Luca and Charles Meltz today in Sarasota County Circuit Court. So back here with the live, folks. And we are going to have to do about a 10-minute live Q&A. Reason being is because I'm back live at right around 6 o'clock Eastern time for the official announcement by Governor Ron DeSantis in Florida alongside Twitter CEO Elon Musk. DeSantis is going to be announcing his candidacy for President of the United States, making his White House run for 2024 official tonight at 6 o'clock. While it's the worst kept secret in the political world, of course, his official campaign announcement, and doing it in a way that is very unique as far as doing it in an audio-only capacity on Twitter is, of course, unique. So doing it alongside Elon Musk in and of itself is unique. So we'll, of course, be covering that coming up in less than an hour from now. So we'll do a 10-minute abbreviated Q&A, and I'm going to do my very best across all of our platforms. I'm going to be paying attention to, we're going to bounce back and forth. Facebook, Twitter, Instagram, and YouTube. You can use hashtag HeyJB starting now, and I will try to get to as many as possible. As I read a few in here already. Mo makes a really good question on TikTok Live on the WFLA JB TikTok page. Hashtag HeyJB, would Roberta's argument of writing before just prove premeditated of knowing beforehand? And to our understanding, based on the letter's contents, the answer to that is no. Reason being is because it does not mention Gabby Petito by name. Now, could a jury read between the lines? It would take, of course, a very compelling argument by the plaintiffs to articulate and convince a jury unanimously, of course, that of premeditation. But I believe that the plaintiffs would argue in this case that they believe that Roberta Laundrie wrote the letter in the aftermath of Gabby Petito's death. I think that is their primary argument, as clearly illustrated in court today. Cliff McAfee Jr., hashtag HeyJB, will you be asking Riley any questions on if he plans to keep the letter hidden? Cliff, the moment this stream is over, or maybe even before it, I'm going to be, of course, texting Pat Riley as far as his intentions with that letter. In fact, why don't we do it right now? and just see exactly what you guys are seeing. I'm just going to shoot him a text. Let's see. My job to try to get to the bottom of the stories that I cover. So we'll see exactly where this goes from here. Let's go to YouTube Live. Hi, YouTube. Christy, Chris, Marianne, and Spicy Burrito. Yeah, the best names are on YouTube. Christy Davis, hashtag HJB. When can we expect the ruling? I imagine you expect the ruling on the motion to dismiss within weeks. Based on, and that's just based on previous tendencies and pacing with this case. I would say in the weeks ahead, maybe in the days ahead. It really depends on Judge Brewer and her schedule and her workload. She has to write, she has to document the reason for whether she approves or denies the motion to dismiss. So it's not just a single line, granted, rejected, or so on and so forth. She has to issue a ruling and explain the rhetoric behind that ruling. Let's see here. Sarah Barrett, hashtag KJB. Can you remind us of how this letter came to light in the first place? Absolutely. That's a really great question. Let me explain how this went. Last year, in the spring of last year, about, I believe it was March or April of last year, 2022, the attorneys for representing all the families here went to the FBI headquarters in Tampa. They were called to the FBI headquarters in Tampa for a very specific reason, to receive back all of the FBI evidence that had been collected. I mean, everything, including, the personal effects of Brian Laundrie. Some of, basically, they have, digital copies of all this at the FBI. But the actual physical items themselves are being returned to the family, each respective family. And as they were going through each individual evidence, because they have to document and log each individual piece of evidence, who it's being given to, and make sure that, because you have to remember, if a piece of evidence is collected and it's unsure if it was Brian's or Gabby's, maybe they both had claim to a particular piece of evidence. Maybe it was if it was a book, maybe they both, maybe they went to Barnes & Noble, for example. I'm just giving an example. Maybe they went to Barnes & Noble and each paid $10 for the book, and then it's, okay, then whose book technically is it? So they have to document who is then retrieving the evidence from the FBI. So as they're going through piece by piece, this letter comes about. Pat Riley examines it. Stephen Bertolino examines it. It, of course, really gets the attention of Pat Riley. Says his eyebrows were raised, if I remember correctly in our conversation. And he knew that was going to, even though it wasn't dated and even though it didn't mention Gabby by name allegedly, he knew that it was going to play a significant role legally going forward. So he just made mental note of it and knew that he wanted to seek it out in the discovery process at trial, ahead of trial. Lar, hashtag AJB. When will we get to read the letter? It's a great question. It's up to Pat Riley. If Pat Riley wants to distribute it to the media, he can do so tonight. He could do so tomorrow. He could do so, but what he is going to do undoubtedly, and I know because I've talked with him about this, he is going to assess the situation legally on what is best for his clients. There is a scenario, of course, where he believes that the best scenario for winning at trial next year is to keep the letter under wraps until next year. And look, you have to remember, we were talking earlier about jury selection and an impartial jury. There's so many factors that Pat Riley has to consider, but he also has to take his client's wishes into consideration. If Nicole and Joe, if the Petito and Schmidt family are sick and tired of this letter being referenced and people not being able to see it, then maybe, Pat Riley could email it out to the media tonight. He could tweet it out. There's so many different things that he could do, but he's undoubtedly going to act in his client's best interest, both legally and as far as personally what they want. Let's see here. We're going to go to 5:20. So we got another 3 minutes. Blue Eagle, you're going to have to follow up here. What if Judge Danielle Brewer granted the motion today for the Laundries? I don't know which motion you're referencing. The dismissal or the motion regarding the letter and the financial records. There were multiple motions, so I'm sorry. I can't answer this without some specificity. So I'll look for your follow-up comment on YouTube Live. Let's go over to hashtag HeyJB on Twitter and see what people are filing in on Twitter. The last platform I haven't read a comment from. I'm not seeing too much there recently, so. Marie in Denver asked, hashtag HeyJB, do you really see the judge keeping the attorney, Bertolino, as a defendant in this case? It seems too far-fetched for me. No, Judge Brewer was the one who ruled, I believe, if I remember correctly, Judge Brewer is the one who ruled in favor of Bertolino being added to the lawsuit to begin with. So she was the one who approved of the plaintiff's request to add him as a co-defendant. I believe that was her, not Carol. So, and I'll go back and triple check. America True Crime on YouTube, hashtag HeyJB. On the other hand, giving that letter out to the public may harm the plaintiff's case. That's up for Pat Riley to determine for himself. Is publishing the letter now, if giving it to the media, a reporter such as me or one of the many other reporters that have covered this story, is giving it to the media now disadvantageous to his efforts to win at trial next year? Guys, this is a really important question. I know that everyone's salivating to read it, wanting to know exactly what Roberta wrote in this letter and to be able to ascertain for yourselves as to whether or not it was written, if you think it was written before or after Gabby's death. Look, Pat Riley is going to do what's best for his clients and his chances of winning, and that is of course to be expected. Natalie Frazier, hashtag KJB. What happens if the dismissal is granted? Then the lawsuit is in jeopardy, and pending any launches at an appeal, which would be, without question, it would be the quickest appeal in civil court history. The lawsuit would be in jeopardy. I'm glad Sean asked this question because we got to wrap up here. And Blue Eagle, I'm giving you just another minute here to follow up because I'm looking for your comment and I don't see it because I wanted to answer your question. But Sean says, is there any word on how long the burn after reading letter actually is? Like how many paragraphs it has? I have been told by Pat Riley, who reviewed the letter. Again, he held it in his hand. He says it is not long. It is short. It is a very short letter. If you're expecting the 8 pages of Brian Laundrie's confession all over again, I have been told it is not that long. It is short. And I think it's written on 2 sides. I think it's written on front and back, according to Riley, based on his recollection. All right, Blue Eagle, I'm not seeing a follow-up there. Stacey's opinion is I don't really think it matters when it was written. Its contents are damaging enough. And Megan, right, this is the common sense approach to this. Megan, I'm very grateful that you bring this up. Since the judge accepted the letter to be added in, wouldn't it seem unlikely that then this would be granted a dismissal? Yes. Logic leads you to connect dots A and B, but at the same time, it's not certain, right? You can't certainly. She reserved her ruling, which is basically a way of saying I'm going to rule on the dismissal at a later date. But all signs are pointing to the motions for dismiss being denied. But I can't I'd be an irresponsible and reckless journalist if I said that with 100% certainty that the motions for dismiss would be denied. There's always the chance that Judge Brewer reviews the arguments more carefully and seems to believe that that Bertolino's addition was overzealous. And look, I'm not going to pretend to know what Judge Brewer is thinking, but we can't assume anything, even given all the signs pointing in one direction. All right, folks, that's going to do it for me. I got to hop off.